Hi everyone, this is Ishita, the legal intern at LEXIS and Company. Today I'm gonna tell you all about the insanity defense, a loophole for criminals. Insanity is one of the most negative scopes of the law in the wrongdoings. It is the battle between the clinical and lawful profession. The madness as protection draws a derivation from the sparse proof craziness is an issue of certainty not measured by the unbendable legitimate test. The new inclinations show the improvement towards the acknowledgement of insanity not as an issue of law but rather as an issue of reality. An intellectually sick individual isn't rebuffed for his wrongdoing as he is without choice. It doesn't imply that the indictment duties were over the weight of demonstrating should be sensible uncertainty, and afterwards the solitary supplication of unsoundness of mind is engaged. It depends on the pragmatic constitution. During the hour of such significant wrongdoing, which was endeavored, the vigilant was experiencing a serious mental issue and was ill suited for valuing the idea of wrongdoing and contrasting right with wrong conflict conduct, thus making them not lawfully idea of wrongdoing. What is insanity defense? Insanity defense alludes to a safeguard wherein a criminal concedes the activity yet declares a non-appearance of understanding dependent on psychological maladjustment. This is the reason it is agreement amount of a reason as opposed to an avocation of what he has done. In Indian legal system, insanity defense is an apparatus in criminal law to save an alleged from the responsibility of a wrongdoing. It depends on the supposition that at the time of wrongdoing the individual was experiencing psychological sickness and along these lines and unequipped for understanding what she was doing. In India, section 84 of the IPC describes the defense of insanity. This law depends on the supposition that at whatever point an insane individual carries out a wrongdoing in any attack of insanity, she doesn't have blameworthy brain to comprehend what she was doing, and the demonstration is denied by the law. Therefore, the insanity law has demonstrated to be a vital in understanding the psychological situation of an insane individual and in reasonable conditions award them exclusion from criminal accusations. So there are types of insanity. First, that is temporary insanity. In criminal indictment, a safeguard by the accused that she was insane for some time at the time the crime was perpetrated and thus unequipped for continuing the nature of her supposed criminal act. One issue with a temporary insanity defense is the weight of confirmation, since any assessment led by a specialist must be sometime later. Hence, just proof should be conduct of the accused immediately before or after the wrongdoing. Permanent insanity. A character with lasting madness might be diminished to a raving neurotic or might be indistinct from typical individual conflict. In any case, she deep down debased insane. Not many of the most fiasco cultists on the planet are characters who have gotten permanently insane through losing their psych orders, being tainted by taboo information and headed towards the opposite side. Indian law defense on insanity. IPC section 84 of IPC says that nothing is an offense which is done by a person who at the time of doing it because of unsoundness of mind is incapable of knowing the nature of the act, or he is doing what he is either doing wrong or contrary of law. Let's analyze the section in detail. By the section confirmation of insanity, isn't sufficient, it ought to be demonstrated that at the hour of wrongdoing the individual was crazy around then, even on off the chances that he knew the idea of demonstration, he didn't realize that it was right or illegal? Notwithstanding the assertion, without a guilty mind there is no wrongdoing, it is exposed to a specific exemption. So guys, that was all. I hope you liked the video. Please do like, share, comment and subscribe the channel. Thank you.